I would now like to introduce our presenter, Rhea Majewski. Rhea joined Donald Legal Services, as the firm was then known, in 2014, and she was called to the Manitoba Bar in 2015. She is the recipient of the Borden Ladner Gervais Award for Professional Excellence and Dedication to the Community, as well as the Tory LLP Writing Award. She has a general practice focusing on civil litigation and family law. In the community, Rhea regularly volunteers for the Women's Resource Center and the Brandon Helping Hands Soup Kitchen. She's an active cyclist who enjoys training and fundraising for the Riding Mountain Challenge MS bike ride. Rhea also has a Bernese mountain dog that she enjoys walking and carting around her community. We are so pleased to have her here today and so grateful for her time and her expertise on this matter. And without any further ado, I will pass it over to Rhea, and I will also get the PowerPoint up for us. Thank you, Rhea.
Hi, everybody. So if anybody has questions as we go, feel free to ask. I have no problem answering questions. It's always a little bit different when you're doing these things virtually, but sometimes it's easier to just answer the questions as you go. So no problem with that. So you can go to the next slide there. So essentially, my goal today is to try to give you a basic overview of a lot of concepts. So family law and family property division has lots of different unique little challenges. I'm trying to touch upon quite a bit of the legislation, and because of that, not everything is going to be super in-depth. A lot of it will be sort of an overview of what you might expect to see. So in Manitoba, the Family Property Act governs the division of family property upon separation or death. So I think that's the first thing to understand, is that if parties are legally together at the time of passing, the Family Property Act still applies, and the ability to divide property exists at death, and it exists at separation. The Act applies to people who are legally married to each other or common law partners. So essentially, a common law partner is defined in the legislation as somebody who has registered their relationship with Vital Statistics. I can tell you in my 10 years of practice, I have met 0 people who have done this, but at any point in time, people can go down to Vital Statistics and they can register their common law relationship. And as soon as they do that, essentially that's akin to being married, and it takes effect immediately. If they don't register their relationship with Vital Statistics, then the legislation says that common law partners come into existence when you have cohabited in a conjugal relationship for a period of at least 3 years. So a lot of people get very confused about this because there are different definitions of common law in various different pieces of legislation. So if you look at the Income Tax Act, for instance, it'll define common law as, I think, within 6 months. If you take a look at the Family Law Act, you can be common law after 1 year if you have a child. But for the purposes of division of property, the ability to have property rights doesn't come into play until you have cohabited together for a period of at least 3 years. The next slide, we'll talk a little bit about what that cohabitation looks like. So if we go to that next slide, a conjugal relationship is found when parties share a relationship, but is based on it's not only found when parties live in the same residence, but it's based on 7 factors. So a lot of times, especially in second relationships or when people are a little bit older, have children with other partners, people don't always live in the same household today. But there are 7 factors to consider, and where you reside is only one of the factors. It also considers how the community views the relationship, sexual behavior of the parties, economic support, social activities done together, domestic services, and whether the parties have children together. So there is a case out of Manitoba. It's a Brandon case, and it involves an older couple who both had their own individual condos. So despite the fact that they each had their own condos and they maintained those condos through the entirety of their relationship, the court found that they were in a conjugal relationship based on the fact that they held themselves out to the community as a couple. So meaning if they went to a party or to a family dinner, they would have introduced their spouse as their spouse or as their partner. They celebrated holidays together. They took vacations together. If one of them went to the hospital, the other was the emergency contact. So all of those factors resulted in the court finding them to be in a conjugal relationship, even though they weren't living together. So I highlight that because a lot of times people will say, well, there is no division of property because I'm not in a conjugal relationship. Not always the case. And it is what I say is if you've been together for a long period of time, you should consider yourself likely to be found to be common law, regardless of whether you share a residence or not. So we can go to the next slide there. So if you are common law partners or married partners, then you are entitled to an accounting and an equalization of all family assets that are not already shared and that were acquired during the cohabitation, subject to certain exceptions. So what that means is that everything that you acquire, whether that's a pension, whether that's a bank account, a vehicle, a house, anything acquired during the cohabitation is subject to sharing, unless one of the exceptions apply that I'll talk about in a few minutes. One of the challenges that happens is that we have to define when the cohabitation started and when it ended. So that's the opening date and the closing date evaluation. In Manitoba, the opening date of cohabitation is when you started living together. So some people think it's 3 years later because that's when the common law definition happens, but that's not the case. It starts the day that you start living together. And at that point, every asset is included in the accounting. It ends the day that you separate. And the date of separation is based upon when one person ends the relationship fully. So it doesn't take two-party consent. If one party says that they don't want to remain in the relationship, that is the date of separation. So generally, property owned jointly is considered already shared. So for instance, if you have a family home and both of your names are on the title, that's usually excluded from the accounting because it's considered already shared. Similarly, sometimes people will have joint bank accounts. Those are also excluded from the accounting because they're already considered shared. Or if a vehicle is in both parties' names, then that may also be considered already shared. So when we talk about what kind of assets are included, it's not just assets that you purchased during the relationship, but it's also the growth in assets that you may have had before the relationship began. So sometimes you have an RSP that you've been saving for 10 years and then you get married. The growth of that RSP is shareable. So any increase in value in that RSP will be part of the accounting, but the original investment that existed at the date of cohabitation will not be. So we can go to the next slide. So one of the largest issues in dispute is often how we value the assets. So assets are going to be valued based on the fair market value, which is generally defined as what a willing buyer would pay to a willing seller. This can sometimes be a large point of dispute for parties. So for instance, let's say that you purchased a Lexus a couple of days before separation and you paid $60,000 for it. That's not necessarily the fair market value at separation because COVID, as soon as you drove a car off the lot, it often lost some value just by virtue of being driven off the lot. I don't know if that still holds true now that COVID's kind of monkeyed with the resale value of vehicles, but that used to be traditionally the case. And so oftentimes people want to set the value at what they paid for something, but that's not necessarily going to be the value. It's based upon what somebody would pay for it at today's rates. So one of the largest issues of disputes for people are often the smaller ticket items like family furniture and appliances, which you may have paid quite a bit for. But at a garage sale, or if you were to put them on a classified ad, no one would pay a lot for your used couch, even if you spent $3,500 purchasing it at the front end. So those can be points of dispute for parties because they want to get back what they put in, but that's not necessarily how the asset is going to be valued. So often we get experts to assist the court So the court does have rules now that if you want to value something, you need to have an assessment of its value done. So that often will include auctioneers, real estate agents, appraisers, car dealerships, or actuaries. It can also include experts in jewelry. So sometimes people have very expensive diamond rings or expensive necklaces that we need a jeweler to explain to us, what that's worth. Um, it's important to understand that this is a place where real dispute can happen, and that the earlier you get an expert to help you evaluate the assets and get you the best figures to use, the easier it is to do. Family property is essentially a math exercise, and what makes it more difficult are going to be some of the emotional attachments to assets that you might feel are worth more than they actually will be on the open market, or things that that people have feelings about their value that aren't necessarily based on the expert opinions. So pensions can also be very difficult to value because their value has not yet vested. So as everybody knows, when you're acquiring a pension, you're not receiving it until the point that you retire, and so it's meant to be invested for a significant period before it starts being drawn upon. And so those are generally going to be assessed by actuaries. So those are mathematicians who come in and use a formula to try to figure out what this asset's going to be worth in the future when it actually vests, and what each party's interest is at the date of separation. Often, if there is a dispute, more than one expert will be used to give an opinion. Where I've seen this most often is going to be on large ticket farming assets or commercial assets. So sometimes corporations, there are differences of opinion about things like goodwill, how much a business would be sold for on the open market. Farming assets, there can be significant differences of opinion about what farmland is valued at, or tractors, or large ticket items that people purchase throughout the course of their marriage, but don't necessarily expect to have to divide. So we can move on to the next slide there. So debts are generally going to be not part of the accounting if they're jointly held. So again, if that's considered already shared, so if you have a joint line of credit or a joint credit card, those will be already shared, and each party has to pay their own half of that debt. If the debt is in one party's name, then that debt is deducted from their total assets, but they still have to pay the debt on their own. So again, this is something that often people will say to me, well, doesn't my husband have to pay half of my line of credit? He doesn't have to pay half your line of credit. What will end up happening is that the line of credit value will be deducted from your assets, and then it will be your responsibility to pay for and deal with that debt on your own. So that's how debt is treated as part of the family accounting. The court does not generally do a negative accounting. So what that means is that on rare occasions, it's not very frequent, but it does happen where families have more debt than they do assets. This is especially true if, let's say, almost all of the big assets are held in joint name. So if your house, where all your equity is in joint name, and your cars are in joint name, and your bank accounts are in joint name, but you have the line of credit in just your name, and your husband isn't on it, or your spouse isn't on it, what can end up happening then is the only thing to divide is debt. When that happens, generally the court says, we set each of you at zero and there is no accounting. They can do a negative accounting, so you can make a special application to do a negative accounting if you're able to demonstrate that that line of credit was a family debt. So if it was used to purchase the down payment of the house, or if it was used to purchase one of the vehicles or something like that, you might be able to show that each party is responsible to pay half. But generally speaking, there will be no equalization, and the courts will not do an accounting if it's in the negative numbers. Can I move on to the next slide there? So as I talked about a couple of minutes ago, the assets are valued at the beginning of the cohabitation and at the end of the cohabitation. So this can actually be a dispute between parties as to when the beginning starts. Usually the end is fairly known because it's happened recently, but a lot of times when you ask people, when did you start cohabiting? If it's 20 years ago, they often have great difficulty determining exactly when they started cohabiting. And that can be of considerable importance depending on what assets are in dispute. So, for instance, if you started living together very shortly after farmland was purchased or something like that, you might have a lot of dispute about when that cohabitation started because depending on when it started, the entirety of the asset might be included or just a small portion. And so sometimes there's separate hearings where the court will determine when the date of cohabitation started. If they do that, they're going to use those 7 factors we talked about earlier. So they're going to try to look at how did you hold yourself out to the community? What was your relationship like? When did you start living together? All of those kinds of factors will be considered, and then the court will make a decision about when it decides you started cohabiting if you can't do it jointly. Oh, sorry. It says that I am too far from the mic in the sound draft. Is everyone hearing me okay now? I'm going to assume the answer is yes.
I can hear you okay. So hopefully
Okay.
somebody else can.
Okay, perfect. There we go. So when you're doing an accounting, each party's assets are told and then their debts are subtracted to get a total figure, and the difference between those two figures is equalized. Often parties don't agree on the individual value of each specific item, and that's when a comparative analysis is best undertaken. I tried to give an example of that because it's very difficult to kind of understand it unless you're doing a math exercise. So the next slide is an example of what this looks like. So in this particular slide, you have Bob and Sally, and Bob has some assets on his side, and Sally has some assets on her side. What you see there is that there's a company, for instance, you have company X, Bob values it at one number, and Sally agrees. And so in that case, those are the same numbers on each side. Oh, it looks like my my assistant updated this and made the numbers all the same. In real life, you might see that Sally might not agree, and she may have put company X at $100,000 instead of $234,000. And for instance, when we look at the house, which is 123 Fake Street, that could be valued at $425, and the other party might think it's worth $480,000. So those sort of differences will result in different totals and different payout figures available. So usually that's where the dispute arises between people because ultimately the assets are usually known. The issue is what are those assets worth and what's included and what isn't included. So that's usually what the largest disputes between the parties are. So these comparative analyses usually help people to really understand how much is in dispute. And so, if it's a small number, it may allow us to be able to get to, there's a question there. To force hidden assets such as accounts only. So the question is, when you're doing an accounting, is there a way for the court to force one of the parties to show hidden assets such as savings accounts only in one name? Sort of. So there's a few different ways that we typically deal with trying to figure out where the assets are. So most recently, I did a case where the husband alleged that he didn't own any cattle. And so we had an entire trial about whether the cattle existed or did not exist. In order to determine whether the cattle existed, we cross-examined the husband, and he had to answer our questions under oath about it. We were also able to get the court to order him to provide records of tax returns and other things that showed the purchases. So ultimately, if somebody is hiding an asset, you typically have to get to it by asking questions. So for instance, if we could see a withdrawal from a joint account, we might say, well, where did that $50,000 go? And the court would then order them to provide documentation as to where that $50,000 went. So if it went to purchase a vehicle, well, now we have the vehicle. But if it just disappeared, the court can make an inference that it does exist somewhere. If you have absolutely no information about the asset and you just suspect somebody is hiding an asset, you're probably going to have difficulty with it. But if you have any information that demonstrates that the asset exists, then we can sort of ask questions about it and get orders from the court for more disclosure. In family law, there's generally a rule that parties need to disclose things and that they need to do that voluntarily without court intervention. So courts are going to help as much as they can to find any assets that exist, but there are still issues sometimes with assets being hidden or unknown. If an asset is hidden or unknown and discovered later, you may be able to come back to the court to deal with it if it was excluded from the accounting because it was hidden. But that's the best answer I can give you to that one. I hope that helps a little bit. So as you can see, what you do is you total the assets on Bob's side, and then you subtract his debts to get the total equity. So again, this is sort of the only place I find that people find this really not intuitive, because people think you're dividing the assets and the debts separately and each party's paying half of each, and that's not really the case. You're just subtracting the debts from the existing assets to get total figures there, if that makes sense. So we'll go on to the next slide there. So pre-acquired assets, I've talked a little bit about that. So those are assets that an individual acquired prior to cohabitation, and they are generally exempt from the accounting. However, the growth of an asset is included unless it was inherited. And even when it's inherited, there are some ways that it can sometimes be included depending on how the growth happened. So I gave the example of a house prior to cohabitation. So especially in second relationships or relationships a little bit later in life, there are assets that you already have. So those might include your bank accounts, they might include houses, they could include vehicles, all of those kinds of things. The challenge that always exists is, how do we determine the value of the house prior to the cohabitation, or the value of the asset prior to cohabitation? With a bank account, for instance, we've been finding that it's very difficult to get the opening statements. So if a couple's been together 15 years and they're trying to go back to what was my bank account worth on day one, 15 years ago, today the banks will tell you, I can't give you that. They'll often say, we're not going back more than 7 years. And it can be quite an undertaking to try to get any evidence of what the bank account was worth at the beginning of the relationship. So that includes RSPs and things like that. It can be very difficult to get the initial statements to show what the value was before the relationship. When it comes to houses, that's a similar problem, because what ends up happening is you're trying to figure out, what was the house worth in 2009 when we started our relationship, and you have to go and get an appraiser or a real estate agent to give you a historical opinion, which are a little bit less reliable and generally a little bit harder to come by. So that's generally the challenge with pre-acquired assets, is trying to figure out what was their value when the relationship started, and how are they going to be divided. So yeah, it's easy. My example is pretty easy, because if you know it's worth 200,000 and then at separation is worth 300, the math is easy. The question is going to be, how do we figure out what it was worth at the beginning of the relationship? So you can go on to the next slide there. Inherited assets and gifts. So oftentimes when I'm doing estate planning or something like that, questions that parties have for me is, if I leave my daughter something, does that mean her boyfriend or her husband or her common law partner gets half of it? The answer is no. They're generally exempt from the accounting, whether they're inherited while you're together or before the relationship. It doesn't actually matter, unless it can be shown that the inheritance or gift was intended to benefit both parties. So for instance, there have been situations where a house was gifted to, so what I've seen in southern Manitoba is often a parcel of farmland is gifted to the family for the purposes of building the family home or something like that. And when that happens, the question is, even though the father gifted it to his son, it was used to build the family home. Was there an intention that it was meant for the benefit of both parties? So there can be some significant disputes about that. And that can be quite litigated depending on what the facts are of the situation. That's when we talk about if the inheritance or gift is commingled with other assets, they can be included if they cannot be sufficiently separated. So sometimes the father might gift his son the parcel of land, and then they might build the house together on that land with joint money, and then put both names on the title. At that point, it's really difficult to determine what's what. And if you can't separate the asset out and sufficiently trace it and say this is the gift or this is the inheritance, the court will include the entirety of the asset. So a lot of times with inherited money, it's placed in a joint bank account, or it's mixed by purchasing a house or using it in an already existing investment, so that we can't sort of see what part's the inheritance and what part is family property. And so when that happens, it's impossible for the court to separate, so they include it. And this can be a source of quite a bit of dispute between couples, because they may think it's not fair that someone's seeking to include an inheritance. And so there can be quite a bit of emotional reaction to this part of the accounting sometimes. We can go to the next slide there. So pensions, within the Family Property Act, it says that the pension is included and is an asset for division. They are shareable, again, from the date of cohabitation to the date of separation. So generally speaking, the way the legislation is worded, and most Manitobans are covered under the Pension Benefits Act. That's our provincial legislation. Some pensions are covered by the Pension Benefit Standards Act. That's federal legislation for things like RCMP officers, or sometimes railroad or federal jobs. But for the most part, most pensions here are governed by the Pension Benefits Act. Under both legislations, whether it's the Pension Benefit Standards Act or the Pension Benefits Act, the pension is no longer automatically divided. So it used to be historically that if you had a spouse and you separated, the pension administrator would separate out the portion that belonged to the other spouse and hold it, and they would only release it if there was a court order or a separation agreement saying that the other spouse wasn't entitled. We do the opposite now. So right now, your pension is wholly yours. And no part is separated for your spouse unless there is a separation agreement or court order that requires it to be divided. And the legislation does allow a party to decide how much to divide. And so a lot of times what happens is, if we're looking at the family home and it has a whole bunch of equity in it, someone might say, I'm going to take the equity in the family home and you can keep your pension. Or I'm going to take the equity in the family home, but I'm going to take 25% of your pension to make up the difference. And so the legislation now kind of lets us do that, which can be quite helpful to parties in figuring out how to pay the equalization payment to each other. You can move on to the next slide there. So joint assets are assets that people hold in joint name. So that means that each party owns 100% of the asset, and they own it equally. And if either party dies, the other one gets a right of survivorship, meaning that they would become the sole owner at the point of passing. This can be the family home. It can include other joint assets like cottages or vehicles and bank accounts. So how joint assets are dealt with is that either party can request the sale of the asset to get their share out. And this is again called partition and sale. So what this means, for instance, is if you had a vehicle and it's in joint name, the party who wants to keep the vehicle either needs to pay for it, or the vehicle would be sold and the proceeds of that sale would be divided based on the ownership, whether that's equal, or if you own slightly less than half, it would be divided that way. So most often this comes up in the context of family homes, and that's why dispute arises around who owns it and what happens at separation, who gets to live in it. things like that. So if you go to the next slide, we'll talk a little bit about the family home. So again, if both parties are on title, often they'll say, well, can I stay in the home, or does my spouse get to stay in the home? Who gets to stay in the home? Sometimes it's actually not infrequent. People continue to jointly occupy the home until they resolve matters. So if the relationship is not violent, if there is not a lot of dispute between people, sometimes one party will live in the basement and the other will live upstairs, or they'll just have separate bedrooms and continue to live together while they list the home for sale, or do things like that. In other situations, that's not the case. So the relationship breakdown has been challenging, and there's just tension in the home, or there could be violence, or there could be just discomfort in residing together. In those situations, either spouse can apply for an order of exclusive occupation. So that is essentially an order that says, I get to live in the home and you're excluded from living in the home. The court will consider a variety of factors, and they can make an order to do this. Often what they're going to consider is who can pay for the home. So they're not going to allow someone to remain occupying the home if they can't pay the expenses. So those include things like the mortgage, the taxes, the home insurance, the hydro, the water, all of those kinds of things. They're also going to consider, though, if it's the case where someone's a stay-at-home parent, does the other party owe them spousal support or child support that might allow them to be able to afford the home? They're also going to consider family violence. So if there's family violence, they're going to think to themselves who the perpetrator of the violence is, and whether the non-perpetrator should be able to remain in the family home. They'll also consider things like, does one spouse have family or friends or a space that they can go right away and the other partner doesn't? If there are children, is one parent primarily parenting the children and needs to get them to school, or things like that, amongst many other factors that can be considered. So that's discretionary, and the court can decide based on a variety of factors. I will tell you, in my practice, this doesn't come up very often. Most often, parties do organically decide who's going to remain in the home and who isn't, or they continue to share the home together. Not always amicably, but often it's done organically without the help of the court. In the absence of a court order, both spouses continue to have equal right and use of the property. So this does become sometimes a point of contention. So oftentimes one spouse moves out because they've just decided that that's what they're going to do, but they don't take all their stuff right away, and so they want to continue to come to the property and get their things, or they want to be able to come to the property and they just sometimes want to be able to come to the property because they think they still own it. And the other spouse says, well, you're not living here, and I want to be able to lock the door, and I don't want to feel like if I'm in the middle of having friends over, you're just going to pop in and use the space. And so oftentimes without a court order, there's agreements between counsel or agreements between the parties that the spouse who leaves is not going to just come to the house willy-nilly and pop in. They'll make plans if they need to come and pick things up. Where disputes arise is when one party says, you can't come back. I'm not going to let you into the property. You don't have a right to come in. And then we get into disputes about that. So in general, the law is that if you're both on title and there's no order of occupation, you can't exclude the other spouse. They are entitled to come into the property, and their legal rights are not affected regardless of whether they're living in the house or not. We can go to the next slide there. So most often a separation agreement is done between parties. So this is a legal document that outlines the rights and responsibility of each party with respect to everything from family property, support, and parenting of children. It's a comprehensive document. And generally it is needed before you can purchase a new property. A bank requires this for financing purposes. The reason the bank wants to see this is they want to make sure that they know exactly what your debt is going to be, or exactly what asset you're going to receive as part of the separation. But they also want to know, are you receiving spousal support? Do you have a liability to pay spousal support? Is there child support being paid or received? Because all of that goes into their calculation of what kind of a mortgage you qualify for. They don't want to give you a $500,000 mortgage if you're going to have to pay your spouse $250,000 and not be able to pay your mortgage out. So ultimately, 99.9% of the time, the bank is not going to give you a new mortgage or allow you to buy a property without a separation agreement. There are rare circumstances where if you have enough assets or something like that, the bank might allow you to finance, but it's quite unusual. Generally, these agreements are negotiated with legal counsel and they're carefully crafted to consider all disputes between the parties. So that's why banks like them, because they're generally quite binding and the court doesn't usually interfere with them unless there's really, 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 really unique circumstances. And so that allows the bank some certainty on what's going to happen. You can go to the next slide there. So prenuptial or cohabitation agreements, I guess it should say postnuptial or post-cohabitation agreements as well. So you can have, you can do an agreement at any time in your relationship. So you can do the agreement before you start living together. You can do the agreement in the middle of living together, or any time in between that. So these agreements can outline what will occur upon separation or death, and they can override the statutory entitlements to division of property, as well as spousal support and joint property. The only thing that they can't handle is parenting or child support issues. You just can't contract those away for the future, but all other rights you can. Generally speaking, this is going to be recommended if you are engaging in a new relationship, especially if there are minor children that are from other relationships. And if there's any uncertainty about what should happen upon separation or how to value things, we really think a prenuptial, postnuptial, or some sort of agreement governing that is really helpful, because it takes away all of those disputes that we talked about, which are what's the value of the asset at the date of cohabitation, what's included, what's excluded, and it allows people to craft an agreement amongst themselves about what they think is fair when they are happy in the relationship and want to treat each other in the best way possible. So I strongly recommend them because it basically gives people a pathway to separate amicably without the need for the court intervention and any dispute about various assets. So other than that, some key takeaways about family property is the first step in any family property matter is to gather information. So that includes obtaining banking information at the beginning of the end of the relationship and obtain values of vehicles and expensive items. Generally speaking, lawyers are going to tell you, we don't want to fight about the family home contents. You guys should decide amongst yourself who gets the Vitamix, who gets the coffee maker, all of those kinds of things. If you really need us to value them, we can talk about it, but for the most part, it's not a good use of lawyers' time to be involved in those kinds of things. But the big ticket items, jewelry, large and expensive jewelry, family homes, bank accounts, RSPs, savings, all of those you want to gather information as quickly as you can and share that information as quickly as you can, because the goal in family law, especially in family property, is to resolve it as quickly and as amicably as we can. So it's not to hide something or trick somebody about what the asset is. It's to just be upfront about what all the assets are and then to divide them as quickly as you can. I always tell people, don't try to stay in the family home if you feel unsafe or uncomfortable. So a lot of times people will say, I can't move out because I don't want to give away my rights to the home. You're not going to give away your rights to the home. You still have an equal entitlement to the value of the home and an equal entitlement to your equity. And you still have the same rights of sale, whether you're living in that house or not living in the house. So if you're unsafe or unhappy in the house, leave. That's really important for people to understand. And then the other thing to keep in mind is that although we're going to try to work as fast as we can to resolve family property, it can be a slow process, especially if there's lots of assets and many years of acquisition. So for instance, if we need to get expert opinions from accountants or appraisers, that can take several months for them to come and get those um, reports put together. And so oftentimes it's not going to be done immediately. And so generally, I would say remember that it takes time and that you should be patient through the process, because it is a difficult process, even if it is mostly a math exercise. There's all these little things that make it challenging. And so just being patient and understanding the process is the best way to go through it. That is a very basic overview of family property.